Hold on. Stop.
Don't.
I'm sorry.
Your Honor, the people did provide me with receipts for payment to a collision center for damages to a vehicle that was involved in the accident with Mr. Walker.
Okay, so let me ask this then, because, say this, I don't mind taking a plea. The court, I mean, he can agree to pay whatever he wants. I just wanted to make sure it wasn't like a no fault circumstance, but obviously it was insured. Insurance only covered a part of it. There was the additional damage, but my only concern on it, we can run into this in cases, is that there are claims for damages that weren't a result of the accident. And if you're sure, then that's fine, but typically we'll set these for a restitution hearing. I take a look depending on the nature of the accident, but.
Okay.
All right. Back on the record in the Nyquist matter, the record should reflect you'd have a bench conference in this case. Going to do something a bit unusual. I'm going to adjourn I'm going to adjourn this for a bond violation hearing as well as a potential plea to March 9th, 2026. What time is best for you guys? My docket normally starts at 1, but that date I can do morning or I can do afternoon.
That day, whatever works for council.
We have class on that day, so let me just
Class.
we don't have
Round class. You don't need class. They're here. This is like a big giant class.
Wonderful too.
What?
I said, and they've been wonderful.
They have?
It doesn't matter. Morning.
Let's get to the morning, Your Honor, please.
They've been wonderful.
They
You don't
have.
have to say that.
I'm gonna keep
No,
saying.
you don't have to say that. All right. Why don't I set it at 10 a.m.?
That'd be great. Thank you.
Right?
Thank you.
Thank you.
Thank you. Thank you.
Bond will continue with its conditions. Oh, he decided to show. Courthouse case of people versus Adib Shawaka.
Morning, Your Honor. Raymond Cook for the people.
Lawrence Margolis with and on behalf of Mr. Shawaka, who is approaching. Adib, please state your name for the court.
Adib Shawaka. Daytime separate final settlement conference. People are able to proceed.
We've executed a waiver to bench.
Shawaka, you understand that you have an absolute and constitutional right to have the matter tried before a jury?
Yes.
You understand that by signing this form, you're waiving that right to be tried before this court without a jury present?
Yes.
Do you understand that? People also waive the right?
Yes, Your Honor.
Based upon the statement of counsel, the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter. We can set this one forward. February 25th, 2026 at 9. That's in person. All right.
Thank you, Judge.
Thank you.
Good weekend.
You do the same. Court calls the case people versus, is it Zeke Church?
Morning, Your Honor. Raymond Cook for the people.
Your Honor, Vincent Hayes on behalf of Mr. Church. Your Honor, can we approach just briefly on this? I don't have Mr. Church present. I can explain why. I'd rather do it at the bench if I could. Thank you.
Proceed. This case is dismissed. That's without prejudice. All right. We'll also dismiss the bond violation.
Well, thank you very much, Judge.
All right.
Appreciate it. Good luck to you.
Court calls case people versus Marcus Stewart.
Raymond Cook for the people.
Morning, Your Honor. T. Brock on behalf of Mr. Stewart, who is approaching to my right. Mr. Stewart, please state your full name for the record.
Marcus Stewart.
Thank you.
And this is daytime set for final settlement conference. At this time, the people are unable to proceed.
With that representation, Your Honor, we would move for dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you. Have a nice weekend, Judge.
You do the same. Oh, yes. Yes. Can you, do that? Okay, you're letting council know that we're doing that. Okay, great. Okay. Court calls the case, People versus Wesley Brand.
Ready again, Judge Portia, please to assist the public defender on behalf of Mr. Brand, who is approaching the podium. Judge.
Wesley Brand.
Terms of the day and separate final settlement conference of the reached resolution of this matter where the claims don't complete then to an added count to a disturbing of the case with its recommendation of final costs.
That is accurate, Judge. I am tendering the signed paperwork, the advice of rights and plea sheet to the court, Your Honor.
Going to be pleading to disturbing the peace of 90-day offense. Then count one would be dismissed upon a successful plea. And they're recommending a fines and cost sentence. That's what I have.
That is correct, Your Honor.
Yes, Judge.
Let's have it one.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Wesley Brand. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes,
All right. Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Understand that?
I do.
You understand you're giving up the right to appeal of right.
I do.
Are you on probation?
I am not.
Are you on parole?
I am not.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
Okay. On June 2nd, 2025, at the location of 2201 Hogback Road, Pittsfield Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I hit somebody with a dustpan.
You hit what?
Hit someone with a dustpan.
Is it a dustpan?
Yes.
Metal?
No.
Plastic? Oh, okay. And when you did that, that disturbed the peace and repose of the immediate area surrounding you?
Yes.
I'm sure it did. All right. Sir, I would advise you, well, I'm going to sentence him now, so I'm
Please.
go through those. So, counsel, have I complied with the court ruling? Would it be proper?
You have, Judge.
Yes, Your Honor.
Yes, Judge.
Anything to you want to say before I impose sentence?
Your Honor, I'm sorry, go ahead.
People just recommend the fines and cost sentence. I believe the defendant's at 77 days credit and being held on other cases.
Yes, Judge. He has more serious matters dealing with right now. We'd ask the court for a low fines and costs and close this matter out, please.
He's not. He's in on other matters. He's not expected to get out.
He'll be here till the next court date is March 23rd.
It's sometime in March, he's being held on a $500,000 bond.
He's not going anywhere, Judge.
And he has 77 days at this point.
Yes, Judge.
Fines and costs is state minimums of $125. 77 days, Washington County Jail credit 77, sir. Thank you, sir.
Doesn't matter.
Thank you.
Okay. Thank you, Judge.
Thank you. Court calls the case, People versus Zachary Burlett. Is that it, Veronica?
No.
Okay.
Good morning, Your Honor. Raymond Cook for the people.
Portia, please, assistant public defender on behalf of Mr. Burlett. Mr. Burlett, please state your name at the podium.
Zachary Burlett.
Your Honor, this is date and time set for final settlement conference. The people are unable to proceed.
Based on that, Judge, we'll be asking for dismissal.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Judge.
Thank you.
Good luck to you, man.
Court calls the case, People versus Mohammed Kahala.
Raymond Cook for the people.
Officer Muhammad Kala.
Ready, Judge Torshio Feaster, Assistant Public Defender, on behalf of Mr. Muhammad Kahala? Kahala?
Yes, sir.
Like,
Just like it's spelled.
you know I struggle. Kahala.
Yeah.
Sorry, Judge.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
We'd be requesting a dismissal, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, sir.
Thank you, sir. And Mr. Kahala, thank you for calling the court to let us know that you were going to be late. I do appreciate it. Thank you. Court calls the case, People versus Quadir Man.
Ready, Judge?
And then on behalf of the Your Honor.
Attorney Feaster, Assistant Public Defender, on behalf of Mr. Qadir Mann. Mr. Mann, please state your name.
In Your Honor, today's the date and time set for final settlement conference. At this time, you are unable to proceed.
Thank you, Judge. We'll be requesting a dismissal.
Oh, people being unable to proceed. Count 2, which is dismissed without prejudice.
Thank you, Judge.
Thank you.
Good luck to you. You said you should. All right.
He did nothing.
He thinks I did.
No, he did nothing. And he's like shaking his head.
I'll take it.
Yeah.
Don't turn down for
Yeah.
credit, Judge.
Working hard. I was sweating. Yeah, you got to take those because you get blamed for stuff you
Well,
did.
yeah, gotta take it.
Court calls the case, People versus Justin Lang.
Attorney Feaster, Assistant Public Defender, on behalf of Mr. Justin Lang. Sorry, this is the one. Mr. Brown spoke to Mr. Lang this morning. Apparently, Mr. Lang is on the way or in the hospital.
Where?
At the hospital. I did speak to Mr. Cook about that. We had a similar situation previously. My understanding is that Mr. APA Cook is not an objection to my requesting a dismissal, as they are not able to proceed regardless. So I'd ask for your court to
You're
please,
asking me to waive the defendant's presence.
yes, Judge, and consider dismissing the file.
I don't think you've ever done that.
That's the first time for everything, Judge.
Sound weird. That's weird.
You did call and talk to Mr. Brown.
Yeah, Dr.
That's what Ron said.
Is that correct, Mr. Cook?
As far as the people being unable to proceed, that's correct, and I would leave it to the court's discretion whether the court wants to grant the defendant's motion.
I'll waive the defendant's presence. And you're requesting a dismissal.
Please, Judge.
People being unable to proceed, this case is dismissed.
Thank you so much, Judge.
Court calls case, People versus Nicholas Mead.
Attorney Feaster, Assistant Public Defender, on behalf of Mr. Nicholas Mead.
Nicholas Mead.
Thank you.
Your Honor, this is the date and time set for final settlement conference. The people are unable to proceed.
Thank you, Judge. We'll be requesting a dismissal, please.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Judge. Good luck to you, sir. Take care.
Also case, People versus Kawande. Okay. Thomas, I set up it.
Ready, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Ms. Thomas. Ms. Thomas, please state your name for the record.
Kiwano Quay Cynthia Rose Thomas.
Okay. All right. Thank you, Judge. I have had a chance to speak to Mr. Cook on this matter and Ms. Thomas. This is apparently a file where Ms. Thomas has circuit court felony retail frauds and a couple that were in the queue to be charged. She wants me to request your honor to consider during the final settlement conference because she wants to do a global plea to resolve all of her retail frauds. I did speak to Mr. Cook about that. He doesn't have time to do that this morning with the circuit court matters, but he would be amenable.
All right, guys. Pelly half main court straight up on cruise control agri hody high. One by one, cases get tossed. Prosecutors ain't ready. Defendants catching breaks left and right. It feels like a chill Friday docket. But then George Walker steps up and suddenly the vibe flips. This ain't a free pass. There's a deal on the table. Paperwork looks clean, but the judge ain't rushing it. You can tell already something about this case just doesn't sit right.
So she's been before me before.
Okay.
Right? She has some retail frauds up in circuit court now.
Let me check to see what their exact status is. I know they are felony matters. I just don't
Right.
know where exactly in the pipeline they are. So we just one second.
I don't see anything.
There's nothing to say right now.
I believe they're still at the PCC and exam stage. I don't think they're yet.
That might be right.
Okay.
Okay. So, in some way, you're looking for a global resolution regarding those, and then there are other.
According to
There are two cases that are in the review queue that have not yet been charged.
Got it.
So rather than just resolving one, Ms. Thomas wants to resolve.
Pardon?
Rather than just resolving the one today, she wants to.
She wants to look at a whole. All right. Here's what I'll do then. I'll adjourn the jury final settlement conference in this matter to April 10th, 2026 at 9 a.m. Jury selection, if necessary, will be April 13th, 2026 at 8:30. Both of those will be in person. If everybody comes to a resolution regarding everything, I can always get this file and bring it. We can figure out how to get that done. Okay.
Thank you, Judge.
That work for you, Ms. Thomas?
Thank you.
You're welcome.
Karen, I did have one request, which is if we do have to come back for that April 10th date, which again, hopefully we'll have everything resolved. The people, since they're witnesses, were here in presence, they were able to proceed. May they be excused at that next date?
They would be
Thank you.
at the April 10th day.
Thank you, Judge. All right. Yeah.
Court calls case People versus Angel Dietrich.
Ready, Judge. Torsion, Mr. Assistant Public Defender on behalf of Ms. Dietrich, approaching the podium.
And then on behalf of the people, Your Honor.
When you arrive.
Angel Dietrich.
Thank you.
And Your Honor, today is the date we have set for final settlement conference. At this time, people are unable to proceed.
Thank you, Judge. Based on that, we'll be requesting a dismissal, please.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Good luck, ma'am.
Good luck to you.
Mr. Dietrich, please approach the podium. The courtroom settles as the judge calls the case for a final settlement conference. Everyone waits. Then it happens. The prosecution speaks up. They're unable to proceed at this time. The room goes quiet. The judge looks up, pauses, and asks for clarification. Moments later, the defense makes the move. Based on that, Your Honor, we are requesting a dismissal. The judge considers it carefully, then delivers the ruling. Since the people are unable to proceed, this case is dismissed, without prejudice. Just like that, the case ends. Not a victory, not a loss, but a reminder that timing, preparation, and readiness decide everything in court.
Court does call the case of the People versus Emilio Vasquez Orellana. I was trying to get the L's and I was trying to get the Y.
Ready, Judge.
And then on behalf of the people, Your Honor.
Torsion, Mr. Assistant Public Defender on behalf of Mr. Vasquez
Orellana.
Thank you.
And Your Honor, today is the date and time set for final settlement conference. At this time, people are unable to proceed.
Thank you, Judge. Based on that, we'll be requesting a dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice.
Appreciate it. Have a great one.
Thank you. Where's they're taking all those?
I don't get this much credit.
He's done nothing.
I love this.
Court calls the case People versus Michael Taylor.
Ready, Judge.
And then on behalf of the people.
Assistant Public Defender Torsion on behalf of Mr. Michael Taylor, who apparently is not present.
Michael Taylor. We don't have a message from him at all.
Okay. For the record, Judge, I will request an adjournment, but I do not know what Mr. Taylor is.
Bench warrant will issue for defendant's failure to appear. Michael Taylor? Yeah. For defendant's failure to appear, bond will be set in the amount of $25,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Judge.
Thank you.
Court does call the case of People versus Anthony Brown.
Ready, Judge? Marshall Feaster, Assistant Public Defender, on behalf of Mr. Brown. Please state your name for the record.
Anthony Brown.
Alexander, on behalf of the people, your Honor, today is the date and time set for final settlement conference. At this time, people are unable to proceed.
Thank you, Judge. We'll be requesting a dismissal, please.
People being unable to proceed, this case is dismissed. That is without prejudice.
Judge, may Mr. Brown go turn in his tether?
Why, does he want to keep it?
No, he does not.
You didn't? No, okay, I didn't know. I mean, if he wanted to keep it, I'd let him have it.
Oh,
but okay.
Well,
Yeah, he can go turn his tether. Yes, sir.
Good luck.
Take care.
Thank you, Judge.
And I'd give one away as a parting gift.
You know, we funded in half.
Court calls the cases, all three cases of the People versus Paris Lester.
Your Honor, Raymond Cook for the people. Conrad Fuller on behalf of Pittsfield Township.
Attorney Feaster, Assistant Public Defender, on behalf of, but not with Mr. Paris Lester, Your Honor. Your Honor, we did reach out to Mr. Lester, and I have spoken to both prosecutors on their file. We did have a proposed resolution, but Mr. Lester is not present. For the record, I will request an adjournment, but I do not know what Mr. Lester is.
Sheriff Lester? No response. Bench warrants will issue in each of these matters. Bond in each case will be set in the amount of $25,000. I'll give a 10% privilege. Those warrants will issue immediately.
Thank you, Judge.
Court calls the case People versus Jonathan Warren.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge. Assistant Public Defender, Torres Feaster, on behalf of Mr. Warren. Mr. Warren, please state your name for the record.
Jonathan Warren.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
We'll be requesting.
Go ahead. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Judge. Good luck to you.
Thank you.
All right, take care. What's left?
Court does call the case People versus James Hagan.
Morning, Your Honor, Raymond
yes.
Cook for the people.
Ready, Judge. Torres Feaster, Assistant Public Defender, on behalf of Mr. James Hagan. Mr. Hagan, when you arrive, please state your name for the record.
James Hagan.
Thank you.
Thank you, Judge. I have spoken to Mr. Cook on this matter. My understanding is he has been in contact with his witness, and they believe they are ready to proceed. Mr. Higgins still wants me to request a dismissal. He believes that the court instructed him to appear in person and all witnesses to appear in person, and he feels that it is unfair that the alleged victim in this case is not present, and believes that the matter should be dismissed regardless.
And Your Honor, for some additional context, our officer did make contact with necessary witness in this case. She indicated that she had work today and could not afford to miss today. In order to make today as a date that she would show up and be responsive. I understand the court's policy of having witnesses appear in person. I would ask for an exception given her work schedule, and I would indicate people are ready to proceed if the court's willing to make that exception.
Again, Judge, I understand Mr. Cook's request, and I just have to echo what my client is requesting. Mr. Hagan is just frustrated with the process. Says this has been a long process, been a few months on dealing with this matter, hoping to put this matter behind him, and he believes that the alleged victim should have been present, Your Honor. And so if not...
The victim is store personnel?
Yes, Judge.
Yes, Your Honor. I have the name and pulled up here. I was employed by the name of Nicole Lindsay, and reading from the email, she said she's unable to attend because she's not able to take today off work.
So let me get this right. She would be coming on a case for her employer.
She has a different employer now. She no longer works with that store. I don't know which store where she works now. Happened out of Walmart. She no longer works with Walmart, which she did at the time of the events and would be our necessary witness.
But we don't know where she's working right now?
I do not.
She just says she's working and she can't be here. I'm presuming Mr. Hagan was working and he had to be here, but I mean, I get he's the one under the jurisdiction of the court, but still, I mean, I make that requirement and I just think she needed to make the time to get down here. So if they want to bring it back up, you have to reauthorize it and you go back in the same.
I'll be right back.
All right. At this time, I'm going to indicate that the court on its own motion is going to dismiss this case without prejudice.
Thank you, Judge.
Thank you.
Thank you, Judge.
They might recharge you, but if not, good luck. Nice to meet you.
I would also note on the case that I would believe that while that employee might be an employee, certainly Walmart could have sent somebody from loss prevention to be here also.
That's what I don't.
Well, what are you doing? I do not need you to sign on to what I'm saying. Bye. Bye.
Thank
Or I
you.
change my mind.
Yes. Sorry. It's the only one left, son.
Well,
What did you do?
and you got.
Have a good weekend, everybody.
All right, take care, Conrad. What are we doing?
I don't know. Okay. He was not sure.
Quick or I want to talk to him. Okay.
We're gonna do that. Do you need me to? I gave you the property.
Are they ready on the agenda? Court does call the case of the People versus George Walker.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Good to see you. Robert Ellman with and on behalf of Mr. Walker, who's approaching. Mr. Walker, please state your name for the record.
George Walker.
I have before me a plea form that indicates that the defendant is going to plead no contest to an added count to a failure to report an accident, the 90-day offense. Upon the successful plea to that charge, count one would be dismissed. Defendant is also going to pay restitution in the amount of that $4,200.
That's correct, Your Honor.
Okay, to whom? Well, let me ask it this way. For what?
For damage to the vehicle. We provided documentation to defense counsel as well as receipts from the repairs.
They didn't provide.
Hold on. Stop.
Don't.
I'm sorry.
Your Honor, the people did provide me with receipts for payment to a collision center for damages to a vehicle that was involved in the accident with Mr. Walker.
Okay, so let me ask this then, because was the other vehicle insured?
Yes, Your Honor. I believe that the insurance did not cover all that. I believe the initial cost, looking at the notes, was in the amount of $7,100. Insurance covered not all of that, and it being a $4,200 out of pocket.
Say this. I don't mind taking a plea. The court, I mean, he can agree to pay whatever he wants. I just wanted to make sure it wasn't like a no fault circumstance, but obviously it was insured. Insurance only covered a part of it. There was the additional damage, but he's only. My only concern on it, and run into this in cases, is that there are claims for damages that weren't a result of the accident. And if you're sure, then that's fine. But typically we'll set these for a restitution hearing. And I take a look depending on the nature of the accident. But
And I guess, Your Honor, in my negotiations and Mr. Cook, I believe the agreement to the restitution was part of getting the offer. I know my client would prefer a restitution hearing.
Your Honor, to help, I guess, assuage the court's concerns, we did speak with the other driver of the victim today. We went over the damages, and I specifically asked that we get an idea of why this number is the way it is. My understanding is pretty much the rear left half of the vehicle, or the rear left part of the vehicle, had to be pretty much almost entirely replaced due to the crash.
okay, so what kind of vehicle are we talking that was?
Sorry, what the exact make and model.
I apologize, Your Honor. I gave you my copy this morning.
Sierra.
What year is that?
It is
I guess I could have looked at it.
2007.
And
Yes, sir.
In your Honor, in the report, there are pictures of the damage. It's so important that for the purpose of the no contest, we have to consider those photos.
Your Honor, can we approach on this?
Hold on a
maybe?
moment. I guess, and I just want to be clear, did the insurance total it, but let them keep the vehicle?
We can find out.
Okay.
The answer, I guess, is no.
$7,000 into a 2007 GM Sierra is.
And Your Honor, from a defense point of view, we definitely agree with you. I mean, unfortunately, this was what we had to do to get the offer. I know, again, if you'd like to set this for a restitution
No,
hearing.
I mean, if that's part of your agreement, I'm just letting you know that the court has some hesitation with that dollar figure. Because because what happens is the accident happens. The insurance is to cover what is part of that accident. Had they not been insured, they wouldn't have been able to get they would have been able to get 1,000 or 1,500, whatever it is. But then to look at a $7,100 bill on a 2007 vehicle, so almost a 10-year-old vehicle, that the insurance will not cover. For me, that raises red flags all over the place. But I mean, if you guys want to go ahead with the deal, he wants to go ahead with the deal. I just want to
Your Honor,
state what the court's reservation in that regard is.
based on your position, can we pass this briefly so I can speak with my client and with the prosecution?
We'll pass it.
Thank you, Your Honor.
Because counsel approach.
Now, this is where things get real. The judge hits the brakes hard. $7,000 on an old 07 truck? Nah, that ain't passing the smell test. Insurance already paid part of it. So the court wants proof that every extra dollar came from this crash. No shortcuts, no funny math. The judge makes it crystal clear. Courtrooms don't run on vibes. They run on facts. And just like that, what looked like an easy plea turns into a full stop.
So what do you think? Should the judge sign off or dig deeper? Drop your opinion in the comments, smash that like button if you rock with fair justice, subscribe for more real courtroom breakdowns, and we'll catch you in the next one.